My name is Josiah Neely. I'm with the Foundation Center for 10th Amendment Studies and also in the Energy and Environment Center. I work with Mr. Loyola and Chairman White. And today we're going to be talking about federal encroachment on state sovereignty and federal hampering of state prerogatives. And I'd like to begin by just asking you to cast your mind back just a few months to the last session. You can't, is this not on? Okay. Can we turn this up? Is that good? Okay. I would just say, cast your mind back just a few months to the last session. Serious, tough budget choices that had to be made by the legislature, and finding a optimal solution to how to deal with the revenue shortfall was hampered by federal strings and federal conditions placed on the legislature, requirements for maintenance of effort, conditional grants from the federal government that prevented whether the issue is education or Medicaid or other issues, limited the state's options in terms of making sensible cuts across the board, and what you end up with is the legislature having to, since certain programs can't be touched at all, they're protected. Other programs really have to be gutted more than what would be necessary. And this is the logical outcome of what happens when the federal government comes in, takes money out of the state in taxation, and then offers it back to the states with strings attached. Says you can have this money, but you have to do what we want. It's very different. I understand as a legislature, particularly when you're in a revenue-starved environment, the appeal of additional federal funds, it can be very hard to say no. But as we're going to hear today from the different panelists, he who pays the piper calls the tune, and in accepting these conditional grants and other federal encroachments, states are giving up their state sovereignty and their ability to govern in the way that's best for them and for their own citizens. We have a very distinguished panel here today. Mario Loyola is the director of the Foundation's Center for 10th Amendment Studies and the author of the law review article, which you should all have a copy of. It's this red booklet here. Prior to working for the center, Mario was in D.C., where he worked as an advisor at the Pentagon, and was an advisor also to the Hutchinson campaign for governor. And he's going to be giving us the basic groundwork. Representative Trojan Lewis actually has a unique perspective in being both in the judiciary and now in the State House. And then lastly, Kathleen Harnett-White, Chairman White, is the director, distinguished fellow in residence, and the director of our Armstrong Center for Energy and the Environment, and the former chairman of the Texas Commission on Environmental Quality, which is the second largest environmental regulatory agency in the nation, and which is dealt with many of these issues, state and federal, with the EPA. So with that, we'll start with Mario Loyola.
Mike's afraid that I might not talk enough, so he wants to encourage me to talk more. So y'all can hear me, good. Well, thank you for coming. Today's panel discussion is an important one, especially from the point of view of legislators. You know, the federal government extends a helping hand to individuals and state governments alike, but as we know, there's no such thing as a free lunch, and that's especially true in the assistance that the federal government gives to the states. As the panel's title and the title of my law review article suggests, it's really a Trojan horse situation that you're looking at when you know, you're facing a budget shortfall and the federal government extends billions of dollars, but they've got these little conditions attached. What's happening there is a more serious, and especially in the long term, a more grievous erosion of state sovereignty. It's not just a concept, it's the practical ability of legislators to really represent their constituents and to be responsive to the preferences of their constituents and to be accountable for the policies that they actually develop and propose and want to implement for the state. In the long term, you know, with every dollar, with every federal dollar that you add to the state budget, the state's control over its own future diminishes. And that's an issue. You know, these healthcare policies, education policies, are policies that that are becoming nationalized progressively with every year that passes, and we have to denationalize them. And one point that I've made at the foundation is that sometimes in order to denationalize an issue, you have to nationalize it, which is why, in order to denationalize a policy, you have to nationalize the issue. And that's why we're trying to work in the Supreme Court, which I'll get into in a second, by filing amicus briefs in key pieces of litigation, such as the challenge to Obamacare. We're trying to work you know, with Congress to pass regulatory reform. All the things that we try to do at the state level and at the federal level, certainly in my center, are meant to try to reassert some meaningful limitation on the powers of the federal government vis-a-vis the states, and some meaningful protection for the states, for state legislators, to be able to do the job that they were elected to do. And that's something that's become increasingly difficult, as we just saw, as Josiah alluded to, as we just saw in the last legislature. The problem, and I'd just like to start by saying the problem goes deeper than just a balance of federal and state power, which can shift over time, just like the balance between the president's powers and the powers of Congress can shift back and forth over time. What we really, you know, I've known about the court packing plan. In 1937, Franklin Roosevelt threatened to pack the court with 5 extra justices if they didn't start approving his New Deal legislation. I think I've known about that since, you know, whatever, 5th grade civics class or something. But it's only recently that I really started to, I've started to see that from a very different point of view. It wasn't just a matter of Franklin Roosevelt trying to bring the Supreme Court to heel. It was really a matter of you know, in 1937, by 1937, the Supreme Court had struck down several pieces of New Deal legislation. They were referred to popularly as the Scorpions. Franklin Roosevelt would call them the Scorpions. And the problem the Supreme Court faced in the 1930s is that the president was against them, the Congress was against them, and the people were against them. And the people were behind Franklin Roosevelt, and Franklin Roosevelt wanted big nationalist programs. And what you really had then was a transition from a concept of federalism that had reigned throughout the 19th century up until the progressive movement and the New Deal, which was, you know, the federal government delivers the mail and defends our shores, and the states take care of everything else. Well, now the federal government was going to take care of everything else. And under the Constitution, the federal government's not allowed to take care of everything else. It's a government of limited powers. And what happened in the 1930s is the national government, the Congress and the President and the people came to an agreement that it was no longer going to matter what the Constitution said. If it said that Congress shall have the power to regulate commerce among the several states, we'll just pretend that the phrase among the several states doesn't mean anything. And we're just going to let Congress regulate whatever aspect of commerce it wants. And that's where, if you think about it, that's where we see a transition from, at least with respect to federal-state relations, we see a transition from a government of enumerated, limited constitutional powers to national majority rule, unrestrained, by any real constitutional limitation, which is exactly what Walter Lippmann and others attacked it for being in the 1930s. Walter Lippmann, of course, had written the 14 Points, was very famous. He was the sort of Thomas Friedman of his day, except that he was actually like a really good writer. And he had been a supporter of the Roosevelts, had been a speechwriter for the Roosevelts, and he turned against it when he realized that these guys were commanding transient national majorities and were knocking down one constitutional barrier after another if it got in the way of what they wanted to do. And if you think I'm exaggerating, just think about, I really enjoyed the president's State of the Union speech a year ago. Actually, I didn't. I hated it, but I liked one aspect of it, which was his reference to the Constitution. I had to hit rewind to make sure that I heard it right, and if you weren't listening really carefully, you would have missed it. This was his reference to the Constitution, okay, ready? He said, imagine if in the 1930s we had failed to pass Social Security because of some rigid notion about what government can and cannot do. Right? I want to go back to the oath that he took. He took the oath of office to make sure that he said, I swear to uphold some rigid notion of what the government can and cannot do. It's obvious that these guys are way beyond the living Constitution and all that. They're way beyond if the country's behind them, as we see in Obamacare, they don't care what the Constitution says. They really don't. They'll argue their way around it, and that's a big problem. It's a big problem because with every dollar that's expanded in the federal budget that goes to the state budgets, with every regulatory program that the federal government decides, as you'll hear from Kathleen in a second, every state regulatory program the federal government decides it wants to revise and impose new conditions on, you see a real erosion of state sovereignty, and as we know because the Supreme Court has told us, state sovereignty matters, dual sovereignty matters, federalism matters because it protects liberty. The purpose of the Constitution was to prevent the accumulation of power at a single central point. And the purpose of federalism, as explained in the Federalist Papers, is to make sure that power is diffused at different levels of government. Well, what we're watching now is the accumulation of power in Washington. And I think you'll agree, I hope you'll agree, that it has to be stopped, it has to be reversed. From the 1950s when the conservative movement got going, it got going in part as a reaction to the federal government expanding beyond its constitutional limitations. And with every generation, the federal government's gotten bigger. The conservative movement has also gotten more insistent on a return to principles of enumerated limited powers. The good news is that the Supreme Court has been on this journey once it abdicated its responsibility for guarding constitutional limits on federal power back in the 1930s, and discovered actually under the Warren and Burger courts that it liked legislating more than judging anyway, so it started competing with Congress to see who could do more legislation. That hit its apogee in the 1970s and 80s when they were inventing whole rights out of thin air, and it was during that time that we had the low point in the Supreme Court's federalism cases. If you're really bored one day or have a very long transatlantic flight and want to go to sleep, you can pick up my law review article, and it goes into a lot of this in some depth. In the case of Garcia, the Supreme Court said, you know what, federalism and dual state sovereignty doesn't need any protection at all beyond the political process, the national political process. So you have your representatives in Congress. If you want to make sure that the states maintain some autonomy, well, you can always vote your representatives in Congress to that effect. And Justice Sandra Day O'Connor made the obvious point, which was, great, so now now federalism depends on the underdeveloped sense of self-restraint of the United States Congress. And that's been, that point inevitably got the Supreme Court to re-examine the issue of federalism. By New York versus United States and United States versus Prince, you had a series of opinions in the 80s and 90s in which the Supreme Court said, no, you know what, it didn't say so, it didn't overrule Garcia specifically, but it said, you know what, the national political process really isn't enough to protect federalism. Federalism is an imperative of the Constitution. It's a categorical imperative. Anything that violates, The federal government cannot tell state officials what to do because that violates the dual sovereignty of the state. That violates the structural framework of dual sovereignty, is the phrase that Scalia used. That's a very powerful phrase, and I think, and a lot of others think, that the Supreme Court hasn't pushed its own doctrine to its ultimate conclusion, to the conclusion that we hope it inevitably will. One of the things that we hope it will do, and I'll wrap up here and turn over to Judge Lewis, is we hope that the Supreme Court's already said that commandeering is unconstitutional. In other words, the federal government cannot tell state governments what to do. It can't tell state governments what laws to adopt. And it can't do that because that diminishes the federal government's accountability for its own policies, right? It makes it look like its policies are really state policies and then makes the states pay for them. And that's unconstitutional. And it's also unconstitutional to diminish state representatives' ability to be responsive to the preferences of their constituents, and that's unconstitutional. Well, if that's true, then the case of conditional federal grants like Medicaid expansion, where in Obamacare, the federal government says, now you've got to expand your Medicaid programs according to the following 17 suicidal policies that we all know are completely unsustainable, or you're going to lose all Medicaid matching funds. We know that if you look at that is an exercise of the taxing and spending power that is just as damaging to your ability to be responsive to the preferences of your constituents as if the federal government told you what to do in a commandeering context. Similarly, in the case that you're going to hear Chairman Wright talking about, when the federal government says, EPA comes in and says, you know what, we're going to look at your state implementation plan again, the one that we approved 17 years ago. And we now decide, because we're now embarking on this fantastical voyage into planetary climate control, that you have to do X, Y, and Z, thing that doesn't make sense to anybody in Texas, or at least not serious people at TCEQ. And if you don't do that, we're going to cancel your program, and we're going to impose a federal implementation plan full of people that are as fantastically minded as we need them to be in order to carry out the regulation of greenhouse gases. And we know that that's unconstitutional because when the federal government says, even if it's a preemptible area, even if they could come in and regulate it themselves, the fact is that they're not. If they were coming in and regulating it themselves and paying for it themselves and being accountable for the ridiculous results themselves, that would be, it would be terrible, but it wouldn't be unconstitutional. But it should be unconstitutional for the federal government to say, we're going to take away your autonomy unless you adopt the ridiculous policies that a transient majority happens to prefer right now, before the next election when they're going to get clobbered. So with that, it's a battle that we hope to win at the Supreme Court, but as we learned in the 1930s, the Supreme Court is just as responsive to public opinion and political trends as many other branches of government. It lives within the realm of the possible, like everybody engaged in politics. And so what we're really counting on is that we are successful in our responsibility as a policy institute, that the conservative movement is able to make enough headway to make these changes possible, and that the American public really gets behind a conception of government that is constitutional again, and that veers away from the tyranny of the majority that we seem to be heading towards little by little, and back towards a concept of constitutional limited and enumerated powers. Thank you very much, and with that, I guess Judge Lewis. Thank you.
Well, let's see if this thing. Okay, I think that's on. Great. Thank you. It's nice for me to be here. And I'll try to bear in mind something Rob Orr just said. Rob said that I probably had a very central role to play in this seminar because I was the person standing between him and lunch. So he's got time, he's got more cards, it's over. My time's up. When Rob stands up, I'm off, I think is the way it goes. But thank all of y'all for being here, I appreciate it. I'd like to visit with you just about the practical Texas, on the ground, Texas budget effects of this federalism, what it does to us and how it sort of ties our hands. The scheme that we have of the federal government and the state governments acting together with regard to grant money to fund programs has often been described as, it is federalism. It's a partnership of the states and the federal government. The federal government has certain roles it wants to play, but rather than directly control those, it goes into a deal with the states, and it provides some or all of the funding, and then the state governments actually administer the programs. If it's a partnership, it's a partnership from hell, and it's going to come to bite us. It is the partnership that you get into when you have a partner. It's a business that you absolutely depend on for your livelihood, and your partner can borrow money with no problem, and therefore has great grand ideas, and the bigger the better, and because the partner can go in there, bring in the money, no problem, but you've got to earn your money. It's real dollars to you. It's borrowed dollars, they could go bankrupt, they don't care. Yours are real dollars. And there's a capital call every year. But you're so desperate, what do? How do you get out? You got in at small increments, but now it's big, and you depend on it, you feel like you can't get out. That's the new federalism. That's what we're dealing with. We are dealing with the partnership from hell. The biennium we're in probably have about 71, I think it'll be more than that for various reasons we'll go over, but say right now the estimate is $71 billion, federal dollars in our budget. Our budget's what, 173.5, I think is what we actually passed. Of that, over $71 billion in federal money. Just as a percentage of our budget, let me give you an idea, and I'm not a numbers person, but these numbers are important. If you go back 30 years and look at the comparison of the total revenues we've got for this state to spend, how much of it is state tax dollars and how much of it's federal payments coming in. 1981, that year, there was 61% of the money was state tax dollars, 22% was federal. 10 years later, 53% was state tax dollars, 27% was federal. 10 years later, 2001, 51% was state tax dollars, 30% was federal. And the next 10 years, 2011, 41% each. So there used to be 40% gap, then 30% gap, 20% gap, now it's even. What a huge difference in this state, and what a dependence we have gotten because of that federal money. And it started off small and it just expands, but it's expanding dramatically. Now it could be said, 2011 we have stimulus dollars, so that'll move that a little bit. So I think for this biennium that'll change, and we'll have a little bit more of a gap in the present biennium that we're in. Maybe 4 or 5% more state tax dollars than federal. But then Obamacare kicks in. And what Obamacare really does, if we get rid of the individual mandate, which I think is likely to fail before the federal government, and they'll kick out the individual mandate, what it really is a program that expands Medicaid. And Medicaid, as many of you know, it's 42% state money now, 58% federal money. But we pay a lot of those expenses. Now, of the new people that are being put into Medicaid, federal government for the first 2 years will pick up all of it, but they force a lot of people who are not now taking Medicaid to be in Medicaid, and then we have to pick up more. So the total, the all funds budget, right now, Health and Human Services budget's $55 billion maybe. I'm looking over at Jeannie, so just give me a yes or no, but about $55 billion. It'll be higher than that because we didn't really fund everything we should have funded in Medicaid, everything we're going to have to fund. There'll be additional expenses to be maybe $5 billion more we're going to have to end up funding of state tax dollars. But $55 billion, I think it could be $100 billion in the next, with all funds, with the additional money for Medicaid that's going to come in. A lot of that increase is going to be federal tax dollars. But see what it does to the budget, and see what it does to the comparison of how much state money we're dealing with and how much federal money we're responsible for. And it makes you absolutely dependent, because once you're providing medical care for that percentage mean, it's everybody. It's 130% of poverty, maybe, is Obamacare. Somebody correct. Is it 130 or 150? Or does it vary? It probably varies in different groups. But basically, once you're insuring that many people, how do you ever stop? How do you ever say no? Because all the hospitals are going to depend on that money, all the doctors. I mean, it's not just the people receiving it. It's every pharmaceutical company. It's every lobby in Texas. So how do you ever say no? And then when they say, okay, we're going to change the rules and we want the states to pick up not 10% of those new people, but 20%, or offer more universal medical care, how do you say no? And right now, we're finding it almost impossible to say no. It's hard to find people to say, look, we're just not going to play that game. And it will get, I think, progressively harder. It's not just Medicaid. I'm talking more about Medicaid, but these tax dollars go into these federal funds that come in. We have, I think, about $11 billion for education from the federal government in this biennium, and about $8.5 billion or so economic development, which basically pays mostly roads. So you get heavily dependent on those dollars. Now, to what extent can we avoid that and say, well, this is coercive? We're putting conditions, for instance, on the Medicaid dollars that we're getting. One of the conditions is you can't change what you're doing. You can't cut that budget. You can't cut Article 2. To what extent can we, or to what extent will the courts intervene? I think that they won't. Mario has an excellent law review article that says why they should, and why putting all these conditions on grants is so burdensome of states it ought to contravene the 10th Amendment. To my knowledge, there has never been a federal court case that says that putting conditions on grant money, federal grant money, violates the 10th Amendment. If it was going to be, it would probably been the Doe versus South Dakota case, in which the federal government, it was the minimum age, Federal Minimum Age Act on Drinking Age Act, and the federal government put a 5% penalty on highway monies if states didn't change their drinking age to 21, and had nothing to do with highways. I mean, some people might drink and get on highways, but that was the only connection. It was totally saying, if you're going to have a state law in a state area responsibility, you've got to do what the federal government says, or you get penalized with federal highway dollars. And they later upped it to 10%. But the Supreme Court's case in that case said that's okay, and they approved it. So the likelihood of, I think, federal court intervening is not great. So that's the situation we're in. That's where we are, and that's the decision that the next legislature is going to have to be dealing with, especially Obamacare. Are we going to be the managers of Obamacare? Because we cannot say no to the federal dollars. Because it was raised in Florida versus the Secretary of Human Services, whatever the name of that case was. There were 26 states joined with it, but Florida was the first case. That's where it was filed. That point was raised. And that's the court. That's the case in the court that said the individual mandate was unconstitutional. You couldn't require people to buy insurance. And that's gone up to the Supreme Court. But another point was raised by the states, and they said, and also, by putting these requirements on the states, you are violating the 10th Amendment. That's coercive. And I think that the federal district judge would love to have, reading his opinion, would have loved to have found that, but he said there are no cases like that. And the Supreme Court, it is one of the points for the Supreme Court, but I think they're giving about, 3.5 hours worth of time to the individual mandate and about 50 minutes or so to the point about the states, Medicaid being too coercive and violating the 10th Amendment. I don't see that changing. That's where we are. At a later time, I'll be happy to take questions. I think I've taken up too much of everybody else's time, so I'll turn it over.
Thank you.
Orion? And all can hear me, correct? It's a good mic. It doesn't echo. The state has, through the Attorney General, about 18 lawsuits now filed against EPA actions over the last two and a half years, and I believe that's a historic high. Several of those argue that, related to EPA's really amazing 11-month initiative to assert authority to regulate greenhouse gases, raise the issue of, raise 10th Amendment issues, that EPA's actions are violating fundamental elements of state sovereignty. EPA acts under, well, many laws, but the law that many analysts point out is perhaps one that grants to federal agencies more sweeping authority than any other to just operate in any corner of the economy, individual conduct, is the Clean Air Act. And Congress, in that law, ceded very broad authority to EPA, to the bureaucracy, to make decisions under seemingly innocuous rubrics like make air healthy with a margin of safety, and you decide how to do it. The original law really recognized what, as we've been talking here, is the dual sovereignty of the states. And I'll give you some quotes still in the statute, but far from implemented. The Clean Air Act asserts that the prevention and control of air pollution is the primary responsibility of states and local government. It goes on to state that Congress will carefully balance state and national interests by providing for a fair and open process in which states and local governments and the people they represent will be free to carry out the reasoned weighing of environmental and economic goals. That's a really nice rubric. That works just fine, I think. Even at that point, in 1970 when enacted, but then steadily to this day, the federal agency increased its, it might call supervision or oversight of the state's implementation of the law, but in a really dictatorial, didactic way. I was, for 6 years, chairman of TCEQ, and that meant all day, every day for 6 years, I interacted with EPA, negotiating, trying to, I think, act under this, that we had the ideas of a better way to implement this. In a nutshell, what this rubric that I quoted from statute is, federal government articulates the federal air quality standards to protect health. State is free to figure out how to implement them. The state is bound to attain those standards, but how it gets there is the prerogative of the state. And at this point in time, nothing could be farther from the truth. EPA uses all kinds of continual reinterpretations of that basic rubric to impose all kinds of micromanaging dictates on the states. In the last 3 years, I would say from my perspective, having observed, unfortunately, EPA almost from its birth, during the Nixon administration, this administration, and I don't say this lightly or easily, is acting as an imperial EPA, state, do X now, upon pain of sanctions if you don't, and with some extra threats that will impose. And I'll give you some examples of those. And these are the now in the legal challenges that the state has against several of the actions EPA took in regard to asserting greenhouse gas regulatory authority. The first one, there were about 4 rules, and they're actually, I think, even not from the legal perspective, as an example of an amazing, creative, bold exercise of federal power. What EPA did in 11 months on greenhouse gases is amazing. One of the rules they have, I'm just going to give you a couple anecdotes because it never ceases to amaze me. They call the Tailoring Rule. And why called tailoring? Think narrowing, think making smaller, tailoring. If EPA regulated carbon dioxide under the express numeric triggers in the Clean Air Act, a permitting universe of now about 12,000 would go to, how about 6 million? And the administrative cost to the agency, to EPA, for just the initial issuance of the permits would be $21 billion. These are EPA's figures. These are not conservative analysts going on. These are EPA figures. And recently in court, right now, they said, and if we acted under the law as written, we would also have to employ 230,000 new employees at EPA. And EPA gives those examples because they concluded they had the authority to rewrite the law because it would be absurd to implement the law as written. Well, the state is eagerly challenging that kind of, I think, arrogance of an agency that they can merely rewrite the terms of Congress. In the Tailoring Rule, EPA, at adoption, not at the proposal of the rule, which has legal issues of its own, changes a basic part of the relationship between the state and EPA in the implementation of the Clean Air Act. Under this rubric, EPA makes the standards. It's kind of like Farmer A, Farmer B. You guys remember? EPA articulates the standard that binds the state figures out how to implement it. The Clean Air Act has a variety of provisions, again, respecting the state authority and its own deliberative process to allow up to 3 years when a new standard comes out. The state legislature may pass a law facilitating the states implement, and certainly if not that, the agency will propose a rule, it will take comment from people, it will be a deliberative process in the state. EPA altered that, which had been more or less in the way the implementation of the Clean Air Act worked for the last 40 years by saying, and I can't remember the exact legend, whatever we say you will do now immediately. And that's what they said about in an effort to rush assertion of greenhouse gas regulatory authority, they said states must include regulation of greenhouse gases now. Well, they allowed 30 days. Texas said no can do. No can do because of the Texas Constitution, which has something called a non-delegation doctrine, where we don't just flip when the federal government comes up with a new requirement, that we have a process that, again, at the very least, the implementing agency in the state will have a formal rulemaking process and to give our legislature a chance to weigh in on it. And EPA said, well, if you don't do it, Texas, we'll impose what they call a construction moratorium, meaning we'll freeze those permits. And this is the most common permit for any new industrial manufacturing activity or any kind of change. We just said you won't be able to do that. You won't have that economic activity will cease. And if you, we also will just take over if you don't do it. You'll have to just cede your state authority to issue those permits. Texas said no. Then EPA issued what Mario referred to. It really sounds rather kind of soft, a federal implementation plan. That's the takeover of the state authority, never fully asserted by EPA in its 40-year history. And again, in federal law, there's a 3-year time period by which if EPA says, if you don't correct that, we're going to issue a federal implementation plan and take over state authority. EPA said, guess what? This one is automatically effective. They call it an interim final rule, which is an odd kind of rule, given that asserting rules, thankfully, in this country is protected by due process rights in the Constitution. That's what all the notice and comment and all of that, that's to protect individual liberty and state authority in my case. So that is what EPA has done. The state, in its lawsuit on both the Tailoring Rule and the federal implementation plan, raises an argument under the 10th Amendment. Also violations of law, the Clean Air Act lasts 3 years, also violation of the Administrative Procedures Act. You didn't give us any time in a rulemaking procedure, but also that compelling the state to immediately comply with a new federal dictate on pain of loss of its state authority or freezing a permitting activity that's essential to the economy. And it would be interesting to see what the court says. We could go on, and Mario's excellent law review article has a lot of insights on this. I mean, the court perhaps hasn't gone this far, but under what has been, the court has called commandeering, that this kind of action by EPA may be the case. In conclusion, there's really a growing body of interest concerned with this, not just on the right side of the political spectrum. There's a growing interest among actually many in the environmental community and many in the academic community and the legal community that there needs to be a really significant reform of the Clean Air Act to restore authority to states. Because guess what? They do a better job of actually improving the environment. They don't look at it as EPA does, one-size-fits-all formula that states do. And Texas has a real good record in doing that, figuring out how can we do it here in a creative way, in an effective way. And so perhaps really what I've seen as unprecedented overreach on EPA, and I could give so many other examples other than just these, I think may not work in the courts too, and we have in initial 2 rulings on the all kinds of litigation against EPA challenges. And Texas is not the only state on some of these things. There's getting to be kind of critical numbers, 27 states, as well as all kinds of other entities. But the court has found that in 2 of the cases of key EPA rules, one recently, the cross-state air pollution rule that Texans may have read about in their newspapers as risking brownouts next year, the court stayed implementation of that because of EPA's failure to comply with, people call them notice and comment, which to me sounds undone. Those are the due process guarantees of the Constitution. Has stayed that rule pending full review of the court, and it also stayed another portion. So we will see what occurs, but the D.C. Circuit Court of Appeals is going to, I believe, get a little impatient with case after case after case, and the pattern is clear. But so it will be a very interesting time to see how all of this is resolved in the courts.
Thank you.
All right, I'm going to open it up for questions, and I don't believe we have a mic, so if you'll just raise your hand, the mic will come to you, and we can all hear you.
Thank you. My question is from Mario, and I was just wondering about his predictions regarding the Supreme Court's thoughts on the individual mandate in Obamacare and what would happen if it actually is not struck down.
Do I get a microphone? Yes. Thanks. I haven't really thought about. I think I've had nightmares about that, but I haven't thought that all the way through. I mean, I think so. You're saying if the individual mandate is not struck down, so Obamacare is upheld as valid. You've got to. There are basically two routes to defeating Obamacare. One of them is through the courts, and the other one is through elections and votes in Congress, and the signature of a president that's willing to. Can we talk about if the court strikes down the individual mandate? I'm so much happier to talk about that. That makes me so much. It's such a feel-good moment for me. Look. I mean, if the court could very well uphold it as valid. Is it likely? Is it likely that the Supreme Court will uphold the entire law as valid? Sure. I mean, is it more likely than not? I don't know. We had a court ruling. It all depends. It depends on. It depends on. I'd love to know what. It depends on what mood Justice Kennedy is in these days. It depends on what mood he wakes up in the morning. It depends if he's getting along with Justice Scalia that week. Justice Kennedy really enjoys his role as the swing vote on the court. We know that we've got. Almost certain, I think the received opinion is we've got Roberts, Alito, Scalia, and Thomas that would almost certainly strike down the individual mandate. The question is, will Kennedy? Kennedy wrote the opinion in United States versus Bond, where he, I don't know if he suddenly had a Federalist epiphany or something, but he was suddenly talking about, how federalism exists to protect our liberties and the diffusion of power among. When I was referring to that earlier at the beginning of my comments, I was thinking of Kennedy's opinion in U.S. versus Bond. So he seems to be of a mood to look very carefully at some of this stuff, and he's the kind of person who he has a propensity to get really hung up on a question like, if the federal government can force you to buy insurance, what can't they force you to do? And he's not likely to be satisfied with any of the government's clever answers to that question. And so we hope that he will strike down the individual mandate. If the individual mandate's not struck down, then we're going to have to go we're going to have to really push for a repeal of some kind. But let me just say one quick thing. I learned a lot in the process of preparing our amicus brief that we filed last Friday for the Supreme Court, in which we talked about the interaction of the individual mandate with the rest of the law, and how if the individual mandate gets struck down, Titles 1 and 2, the health insurance reforms, the Medicaid expansion, all those things that depend upon the individual mandate need to get struck down too, because what's going to happen is what's called an adverse selection spiral, which is if you guarantee, if you pass a law that says insurance companies must issue insurance to all comers, then people are going to wait until they're sick to get insurance. When people wait until they're sick to get insurance, the risk pool starts diminishing until it only contains people who are sick. And then premiums go up to take account of the added per unit cost and so forth, and the more premiums go up, the more you push healthy people out of the risk pool, and it turns into this thing called the adverse selection death spiral. And it's really critical to understand that in 8 states, New York, New Jersey, New Hampshire, a handful of states that we discussed in our amicus brief, during the 90s, they passed this kind of reform, like precursors to Obama. And in order to keep it from resulting in an adverse selection spiral, they allowed insurers to exclude people who had pre-existing conditions. So if you waited until you got sick to get insurance, you weren't going to be able to get insurance. Now that didn't work, right? The purpose of that was to prevent an adverse selection spiral, and it didn't work. In every one of these cases that they passed guaranteed issue regulations in the 90s, within 3 or 4 years they had driven all private health insurers out of the market. Individual health insurance collapsed in the state. That individual means the 10% that's not regulated by HIPAA, that wasn't regulated by HIPAA before Obamacare, the group plans, right? So the individual market, which is outside of the group plans, collapsed entirely in these states because of adverse selection. And so then, including Massachusetts, and then when Massachusetts took up its reforms in 2006, it said, you know what, in order to fix this problem, we know that pre-existing conditions, prohibition on pre-existing conditions, I've had to practice saying that. Prohibitions on pre-existing conditions exclusions are not going to fix the problem of adverse selection. We need something bigger, such as an individual mandate, and force healthy people to stay in the insurance pool. That worked at first. And so from 2006 to 2008, when Congress took up health reform, they had the experience of Massachusetts, and they were like, all right, that's the one thing that appears to work to prevent an adverse selection spiral. So that's why the individual mandate was fundamental to the whole plan from the very beginning. But then adverse selection started setting in Massachusetts. And it kept setting in even as they went through the whole legislative process and passed Obamacare. That's all a very long-winded way of saying that if repeal doesn't look very likely now, the fact of the matter is that adverse selection could still set in even if the individual mandate remains in place. It's guaranteed to set in if they strike it down, but it could still set in if the individual mandate remains in place. So basically, you could have, even if the individual mandate remains in place, this entire disaster of a law could push the health insurance market in the United States to the brink of collapse in a matter of years.
Isn't that the intention?
Well, and then you've got, of course, some people would say that the intention then is to leave nothing but a subsidy, right? Because there's an option to forcing everyone to buy health insurance, which is to buy it for them, right? Which is the idea of Medicaid expansion and the premium support. I mean, we're going to have the federal government's going to be paying subsidies to individuals who make more than $50,000 a year. I mean, we're talking 400% of the federal poverty level. It's like 70% of the population of the United States is going to be eligible for either Medicaid or premium support subsidies. And if the adverse selection spiral sets in with respect to the premium support subsidy people, they're capped. They're going to be paying no more than whatever it is, $5,000, $10,000 a year in insurance. The federal government's going to have to pay 2 or 3 times more than CBO scored that it would be paying. So it's going to blow a huge hole in the federal budget. Anyway, long story short, the prospects are not dim. The bad news is that this law is going to produce a disaster if it's upheld. The good news is that it's going to produce a disaster if it's upheld. So.
Yeah, can I say just one additional thing? And I didn't catch your name. Huh? Corey. Corey, one other thing about that, just to be clear, there are two questions about individual mandates before the Supreme Court. One of them is the individual mandate constitutional or not? And the other one is, if it's not constitutional, what does it do to the rest of the bill? Because there's a lot of the rest of the bill. It's the rest of the bill that affects the state government. And does it make it all unconstitutional? There's a severability provision in that bill. And so the district court said, federal district court in Florida said, individual mandate's unconstitutional, and it makes the whole bill unconstitutional. It's not severable, it's dead. The appellate court said, yeah, the district court was right. I think you know this, Court, but just to mention, the district court was right about individual mandates unconstitutional, but it's severable. And so only that part of the bill is gone. All the rest of Obamacare, all the Medicaid stuff that's going to kill us and make probably our budgeted GR, that's right now $17 billion for Medicaid. The next time the legislature meets, they're probably going to be looking at $30 billion. $13 billion in GR increase. Well, what school kids does that kick out of school, or roads that don't get built? But anyway, that's what that does. That could still stay in play. Just want to be clear on that.
All right. Other questions?
Talked a lot about
what he'll.
Talked a lot about what.
Microphone.
About what the courts can do about it. What can the legislature do about it? I guess that's addressed to you.
Actually, Senator Larry Taylor, I think, is going to be handling that on the Senate side. I know that the House is going to do the right thing. I've always worried about the Senate, but I'm not worried about them anymore. What can we do about it? Here's where it really hits the road, is these are, quote, optional federal programs that we sort of don't dare do anything with. There are true needy charity cases. There are disabled people who need disability services. There are people in nursing homes. There are people who have, with no family to take care of. There are needs that Texas traditionally and always through our history would take care of. And some of these Medicaid dollars go to those folks. What has happened is that under this program, and not just totally under Obamacare, but especially accelerate on this program, what they've said is, if we're going to give you dollars for these really needy people that you really want to put your money in and you want to help, you've also got to have a huge welfare program of entitlements, of people who are not even in the poverty line. You're going to have to do it all. You're going to have to take the whole program. And so what the legislature is going to have to look at, and not just the legislature, the governor, is going to have to look at, is what do we do with this? Do we say, yes, we're going to do that? Or do we go to brinksmanship and say, no, we're not going to play that game? It is optional. You don't have to take this money. And the consequences, I think the political consequences will be incredibly severe. But we've kind of been whistling past the graveyard saying, well, we'll just keep on and something will happen. Depending on what happens in the federal government. There are options. There are block grants. The Bush administration turned down our request for block grant when President Bush, George W. Bush, was in office. But there could be other presidents who would say, yes, that's a good thing. And I know that some of the candidates have said they would. That would help us. And, of course, the repeal of Obamacare would help us. But otherwise, I think we've got a real decision. And if we're looking at increasing GR for just Medicaid by $13 billion next time, we'll have some new revenues, obviously, but we've also got many other needs. I mean, the legislature is going to have to look at that and say, is this a game we can continue to play? And I think the political costs of not playing are going to be very high, but I think it's probably unsustainable where we are. That would be my opinion.
Okay. I'd like to ask a question as much as I'd like to ask more about health care, to shift to energy for a moment, something that's should be near and dear to us in Texas, but also to the nation, because it's without energy, we wouldn't be using this microphone right now. And this question was initially directed to Chairman White. What do you see as the effect on Texas of some of the EPA moves relative to hydraulic fracturing and other aspects of the oil and gas industry?
Well, for a little perspective, until the last 2 years, when we're talking about upstream oil and gas exploration, extraction, that was really a state regulatory thing. And with actually some very, I think, effective regional entities, Groundwater Protection Council, which has been particularly active in response to the new technologies, directional drilling, hydraulic fracturing, and all of that. EPA really didn't, that worked more or less. Now they have not. I'll get to my conclusion first and then fill it out a little bit. I think it's hard to say. They're heading down a path for the first time to very significantly regulate oil and gas production from a variety of angles. They have never done so in the past. But I think it's, there's even for this administration, a difficult policy question to impede the productivity of this historic upsurge in oil and gas production, which is becoming so palpable in so many states. So I think it's up for grabs. They are what they put in place. They have proposed the first ever. They're called New Source Performance Standard, but I call that the heavy-duty hardware, the Clean Act regulation on upstream oil and gas. Those are considered under the Clean Air Act fugitive sources, meaning a lot of little sources rather than a major stationary source industry where you have, and they've always been considered de minimis, or except with something as soft as best management practices, something that could be addressed. But I think, I will speak bluntly, I know this is policy and not politics, but if President Obama is reelected, I think they're likely to. If they are rash enough to deny the extraordinary assistance on reducing their deficit, that a continuation of what we have going on in this country in oil and gas production is, you have, and this was, people were there this morning on the Bill Bennett radio show, but when you have many analysts now talking about the U.S. being the largest oil and gas producer in the world in 5 to 7 years, and you already see the projections for the potential increased production, it's an economic game changer for the nation. And to imagine EPA at a time when government is clamoring for revenues and job creation in the private sector. So they are set on a course to have major impact. But I can't conclude because I can't imagine the folly of their so doing.
Anyone else?
Hi, this question is for Ms. Hartnell-White. Assuming you agree, as I do with Adam Smith, that in order for the market to function efficiently, all costs have to be internalized into the price of a good. I'm wondering how you propose that the market could solve the problem of pollutants, whether it's carbon dioxide, and if you don't believe in global warming, let's talk about mercury or NOx or VOCs. How do you propose that the market solve those pollutant problems if that's not the role of the government?
I think appropriate regulations solve those, what economists call externalities imposed by the productive activity, but they have to be the right kind of regulation. It's actually based on facts and rigorous science. And what we have, and it wasn't again just this administration, but what we have going on at EPA now, and again, and it's not just the last 3 years, but as we reduce pollution and have over the last 40 years more and more and more, over the last 20 years, the 6 major pollutants regulated under the Clean Air Act, called the criteria pollutants, have been, the national average emission is 50%. Like sulfur dioxide, which is much at issue, in the rules pending or adopted now, those have all been nationally reduced by something like 56%. There's a major, the regulations, I think, which over time incrementally achieved that reduction were perhaps an appropriate, perhaps not the most efficient, but appropriate way. Now you have EPA doing what toxicologists call going below zero. They are finding risks to health at any level of a pollutant in the air. And you know what? There is no air that's without something as a result of human or animal activity or climatic activity in the air. So I think regulation can be, but we have had, because the authority in the current law is so broad, and if you have zealous regulators more interested in control than genuine environmental improvement, you get a very, very manipulated, hyped risk assessment. And I just might give you a little bit example on mercury. Mercury emissions at power plants in this country on an average have already been reduced by about 60%. Very generically, this new rule would require a 91% reduction of the remaining in a fairly short period of time. U.S. power plants, these are government figures, emit about 29 tons per year. Chinese power plants emit about 400 tons per year, and one volcanic eruption or a wildfire like we had in Bastrop County that took 3 hours to put in tens of thousands of. So it's a question where, to me, there's not in any way an accurate risk assessment to justify that rule.
Can I jump in with
Sure.
a word about that too? And I've been practicing saying this the way that Richard Epstein would say it, but I'm not going to get you with that now. But the law of torts developed a concept called the Precautionary Principle decades back, which said if you're engaged in some potentially the activity is potentially damaging to somebody else, normally their recovery is when you actually commit some harm to them, and then you measure what their damages are, and then you have to compensate them for those damages. But if the cost to you of taking precautionary measures is dramatically outweighed by the potential damages, then you have an obligation to take those precautionary measures. That's a sensible principle. It's a market-based principle, actually. But when regulators started to use it, they kind of went crazy. And I think if you look back at the history of health and safety regulations in the United States, the country has become, at least the regulators have become kind of stricken by this madness that where they apply precautionary principle everywhere, no matter what the costs, right, of the precautionary measures are in relation to the potential harm that they're trying to prevent. And so you've got many examples in the EPA regulation, because the EPA doesn't do cost-benefit, right? They don't say this regulation is justified by, we are required by law to impose these costs. And the costs that they're imposing on the society are, tens of billions of dollars in costs imposed on the society as a whole to prevent really marginal risk of much lower loss to like some small population. And even when they try to explain what risk of loss they're averting, they use, it's all highly speculative, because if we might damage somebody, if there's some probability, then, we have to take a precautionary measure and impose these costs. And now it's gotten to the point where American businesses pay twice as much. It costs twice as much to comply with environmental regulations as they pay in taxes. And by the way, American businesses are the most highly taxed businesses in the developed world outside of Japan. And it's amazing that we have any job creation at all with the regulatory burdens that EPA and those are imposing on the taxes, and between the regulatory burdens and the taxes. And what's the terrible thing about it is, and Chairman White alluded to the science part of it, is, look, I mean, from my point of view, I studied a lot of biology and zoology and paleontological history and stuff when I was in college, but that was in the 90s, and in the 90s, we weren't talking about climate change. We were talking about chaos theory. Some of you remember, some of you old enough to remember chaos theory. Chaos theory is the idea that, big fat in the 90s, that if there's a butterfly in China, it could cause a tornado in Kansas. The idea of chaos theory, of course, was that there are some systems that are so complicated that you have so many inputs that you can't predict how the system is going to behave. And the classic example given of chaos theory is the climate. It's what scientists knew. It's what scientists were like, this is very interesting. Here's a system that we don't understand and have no hope of understanding. Then I graduated from law school, went to Puerto Rico for a year and a half to practice law. I came back and all of a sudden everyone understood the climate. I don't know what happened. But I just want to say, look, if they can measure changing temperatures, okay, it would surprise. Look, the climate's always changing. It's always changing, right? We're in an interglacial period. We've just come out of an ice age. We're going to head into another one. The climate's always changing. So it doesn't surprise me that they're measuring some variation in temperature or whatever. But when they go from there to say, so we're not denying climate. I at least don't deny climate change. I would deny somebody who says there is no climate change. It's impossible. The climate's always changing, right? Now, what we don't know is what rate, what influences it, et cetera, et cetera. When the scientists go from the observation that the climate is changing to explaining why the climate is changing, and particularly to modeling what the human impact is on the climate, they are speculating, and they do not know what they are talking about. And they should be much more honest about that, because that speculation, the same speculative health benefits that motivate so many of the precautionary measures that EPA imposes on the entire society, is at the root of the greenhouse gas regulations. I mean, they're threatening to impose tens and tens of billions. That 6 million figure, the 6 million permits that Chairman White was talking about, this is half the restaurants in the country would potentially have to close if greenhouse gases are regulated as a pollutant under the Clean Air Act. I mean, these restaurants, mom and pop businesses, are going to have to apply for $60,000 licenses, because they have a boiler, they have a boiler in the kitchen. I mean, I need 250 people sitting in a building. Like right now, I don't know if there's 250 of us, but if there is, if we sat in here for a year, we'd be violating the Clean Air Act. If we just sit here and breathe, this is clearly ridiculous. And what's at the root of it is a science fad. Just like chaos theory was a science fad in the 90s, we've got the exact opposite science fad now. And God only knows what's coming next, but I guarantee you that something is coming next, and that sooner or later people are going to get over the current one, and not a moment too soon as far as I'm concerned. But the point of it is we've got to restore rationality, practical rationality, to our environmental regulation. The states know what they're doing. They know the environment that they're, and I just think the original conception of the Clean Air Act, where you have national standards and you let the states compete for effective, cost-effective ways of reaching them, is a good model. It's not that we're anti-regulation. We just want sensible regulation. Is that really too much to ask? No, right? Okay. Thank you very much.
We are out of time, and I don't want to keep anyone from lunch, but I'd like to thank the panelists. And thank you all for attending.
I think it was an honor to be on that. I'm a West Texas, by the way. Oh, I didn't know that. Thank you. Thank you very much. It's that. Thank you very much.
Oh, and I forgot to say, if you thought this was a good panel, please don't forget to fill out your evaluation form. There wasn't an earlier version. There's actually an anti-severability clause when you think arguably, because there's a finding in the individual mandate that says this is necessary. The other parts of the law will not function without it, which is at least an implied non-severability clause.
Can I just announce that I know you?
Thank you very much. How are you, sir? Good to see you. Thank you very much. Go ahead. Go ahead.
If I recall correctly, the fact that it's not a severability clause is why
Well, there's another reason that's even a more important reason, which is that the individual mandate is inseparable from the Title I and Title I provisions.
That's why
Yeah, right. Well, that's why there is a non-severability clause in it, right? I mean, when you really get down to it. So, yeah. So read out, I think at lunchtime they're going to lay out the amicus brief that we filed in the Supreme Court on Friday.